Hello and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your CPD requirements, and at the end of the podcast we will explain how to get in touch if you wish to claim CPD points or if you have any comments or questions.
Hello and welcome to podcast number 109. In our continuing quest to bring you all the news that's fit to print, we've got three cases for you, two from the AT and one from the Employment Tribunal. The AT cases deal with two rather different points. The first is a useful explanation of the applicable law, where an employee is dismissed for failing to comply with a relocation clause when a business is moving. Is that a redundancy dismissal or is that a misconduct dismissal? Secondly, we have a case where the AT has to grapple with the relevance of historic warnings that have been given to an individual. The warnings have all expired, but they're taken into account in deciding to dismiss the employee nonetheless. Thirdly, we have another gig economy versus the rest of the world case. I'm sure it'll surprise nobody to learn the current score is workers 2, gig employers 0. As usual, don't forget you can access our podcast via iTunes, it's on the Mayor Brown website, it's on YouTube, and the Twitter feed, Nicholas Robertson at Nicholas ROBER11, and we put out the links for the cases there too. So, first up, Kellogg Brown and Root, UK Limited, and D. Fitton. Let's start with this one. EAT have this to deal with. The employer, back in 2011, takes over a company, and it's the company that employs the two claimants. At that point, including the employer that has just been bought up, the group has two sites, one in Leatherhead and one in Greenford. Both of the individuals worked and had always worked at the Greenford site. One had been working there for about 10 years, the other had been working there for about 25 years and was only a year off retirement. The relocation clause in their contracts of employment might tactfully be described as interesting. It said, "The location of your employment is wherever, but the company may require you to work at a different location, including any new office location of the company, either in the UK or overseas, either on a temporary or a permanent basis. You agree to comply with the requirement unless exceptional circumstances prevail." Unquote. So, looking at this, the company can make the individual work anywhere in the UK or apparently overseas on a temporary or a permanent basis. However, if exceptional circumstances prevail, the contract doesn't give them the right to make that move. You can see where this is heading, can't you? Well, during 2014, the employer decides to close down the Greenford office and have employees who are based there all move over to Leatherhead. They're just going to have a Leatherhead site. And they give them effectively 3 months' notice of the proposed closure of the Greenford site. One of the claimants pointed out he'd now have a 2-hour commute each way to and from Leatherhead. Currently, he had only a 20-minute commute. He didn't have a car, he'd not driven for many years. The other claimant contended that he had exceptional circumstances, given his long service and the fact that he was only a year off retirement, and in effect this would require him to drive 47 miles each way rather than 18 miles each way. The employer took the view that age and length of service did not qualify as exceptional circumstances. Neither employee attended for work at the new site. A number of employees did leave the employer at the point of transfer because the employer accepted that there were exceptional circumstances, and they did get paid what apparently looked like a redundancy payment, according to the AT. However, the two claimants here were both dismissed because of their failure to relocate, which was viewed by the employer as amounting to serious misconduct, justifying summary dismissal. Unsurprisingly, both employees claimed unfair dismissal. The Employment Tribunal decided the individuals had been made redundant. The basis for their dismissal was the closure of the office, and that was the trigger point, they said. It was not a conduct dismissal, and the employees were in fact dismissed by reason of redundancy. Their dismissals were found to be unfair. The tribunal did not accept that the instruction given to relocate was reasonable. The greatly increased travelling time certainly was a material factor in the tribunal's decision. They also took into account the employee who was only a year off retirement and whether or not it was practical for him to relocate. Following on from that, therefore, it was also procedurally unfair because they were being dismissed for misconduct when, in fact, they should have gone through a redundancy dismissal process. Not surprisingly, the employer appealed. The key, and to be honest, I think the most interesting point, is the EAT's views on the reason for dismissal. The EAT went back to first principles. They referred to the case of Abernethy and Mott, Hay and Anderson, which is now more than 40 years old, and said that the reason for dismissal, which has to be evaluated for fairness, is the set of facts known to the employer or beliefs held by it that causes it to dismiss the employee. Here there was very little doubt in the AT's mind that the employees were dismissed for failure to comply with the employer's understanding of the contractual mobility clause. The fact that dismissals took place against the background of a redundancy situation did not mean that the employer was dismissing by reason of redundancy. Pausing there, I think this is quite a commonly held misconception, and we've come up against this a few times, but I think the AT is plainly right. Just because a redundancy situation exists does not mean an employee who is dismissed at that point is necessarily dismissed because of redundancy. Similarly, we've had cases where an employer has dismissed an employee for misconduct and then has decided not to replace the employee. The employee sometimes tries to claim that this was a redundancy dismissal. It's not, of course, it's a misconduct dismissal and needs to be judged as such. And that brings us on to the second point. Here, the employer's appeal on the fairness of the dismissal was not accepted, and the tribunal was found to have come to an alternative factual decision it was entitled to do so. And this, I think, is the sting in the tail for employers. It's all very well having a relocation clause, but the AT, and indeed the employer too, accepted during argument, there had to be reasonable notice given about the relocation. I don't think that was an issue here. And the employer has to exercise its discretion in a way that does not make the duties impossible, and that there is an overlap between the duty of mutual trust and confidence and the express contractual mobility clause. Here, the factors pointed out by the tribunal, increased length of travelling time, etc., did allow the tribunal to decide the two claimants were unfairly dismissed when they were dismissed for not complying with an order and instruction that was unreasonable. I wonder if it would have been any different if there had been a more clearly drafted relocation clause, which would also be narrow. So, for example, if it did not require relocation to anywhere in the world, but had said you can be required to relocate up to 50 miles for your place of work. That might have still had a significant impact on the travelling time, but it would have been clear and unequivocal. Equally, in some cases, we've been involved in relocations of business where the issue of travelling time has been a factor for some employees. Often employers will look to say to employees, look, please try and relocate to your place of work, and if after a period it's proving simply impossible, then we will reconsider the redundancy issue. Employers are often desperate to get the workforce to relocate, unless they're looking to slim things down at the same time. And they don't want to allow employees to start to disappear piecemeal in the run-up to location. And of course, once you've granted one redundancy, the floodgates may open with others who you're very, very keen not to lose. So that's the case of Kellogg Brown and Root, UK Limited and Fitton. So next up, Stratford and Autotrail VR Limited. This is an unusual case about expired warnings being taken into account and whether they can justify the dismissal of an individual. It's probably best to start with the facts to put this all into context. The claimant started working for the employer in 2001. He had a very poor disciplinary record with something like 17 separate disciplinary matters on his record during the 13 years he worked at the company. However, at the time of the final incident, all previous warnings had expired. He committed a further disciplinary offence in October 2014. And the findings of that disciplinary hearing were the offence by itself was not gross misconduct and merited only, quote-unquote, a final written warning. However, the disciplining manager wanted to dismiss the employee on the grounds there had been a breakdown in mutual trust and confidence. In addition to the now 18 disciplinary actions, there had been, according to the manager, a number of informal conversations. The claimant had reassured the manager on many occasions that he'd turned the corner, this would be the last time, etc., etc. The manager came to the conclusion the claimant had been given every chance, and in the circumstances, a decision would be taken to terminate the employment on due notice. The Employment Tribunal found that the reason for dismissal was the manager expected they would be having a similar conversation again in the near future, and the manager believed the claimant would not change his ways. As such, this was found to be a dismissal for misconduct, rather than perhaps some other substantial reason, which is probably how I'd have categorised it. Nothing turns on that. This, of course, then brought into sharp focus whether the employer was entitled to point to the previous significant history of disciplinary action to justify the employer's belief the claimant would not change his ways and therefore they would be back again considering misconduct at some point in the future. The AT were happy to uphold the tribunal's decision that the dismissal was fair. There was no error of law in allowing the employer to take into account the previous record alongside this particular offence for which the claimant had been given a final written warning. And the manager's prediction as to how the future was going to turn out if the employee was not dismissed was one that was open to the manager. As I've said a couple of times already, obviously these are exceptional circumstances. Many employers will be familiar with the individual who, when challenged, raises his or her game by just enough to stay out of trouble. In these circumstances, an employer losing patience and saying the employee should not be allowed to play the game is understandable. I think the danger is that the employers reach for this case too soon. There have been many years and many disciplinary issues over those years. In the circumstances, I think employers have to have good evidence before they can dismiss based on previous warnings for a breakdown in trust and confidence in the belief that an employee will simply reoffend if this is not addressed at this stage. So that's Stratford and Auto Trail VR Limited. Third and final case, Dewhurst and City Sprint UK Limited. This is an employment tribunal case, but given that it deals with the ongoing challenges for employment rights in the gig economy, I do think it's worth discussing. The individual is a cycle courier working for City Sprint. She brought a claim for unpaid holiday pay, which, of course, depends on her being a worker. The contract itself was very clear that the individual warranted that he or she was self-employed and was neither an employee nor a worker. According to the contract, the courier had the discretion as to how services were to be performed at all times, including the route taken. There was no obligation to accept or be offered work. There was a limited substitution clause, and indeed the individual could back out of jobs that had already been accepted by the individual. It was therefore common ground that if the contract was taken at face value, the individual was not a worker. Therefore, the issues were was the agreement the true agreement between the parties? Secondly, was the claimant a so-called Limb B worker? I'll come back to that. And finally, when was the claimant working, if they were a worker, because that was going to affect the amount of holiday the individual was entitled to. The relevant statutory definition, the Limb B, in the legislation, states that a worker is an individual who, quote, works, or normally works, or seeks to work under any contract, whereby he undertakes to do or perform personally any work or services for another party to the contract, whose status is not, by virtue of the contract, that of a client or customer of any professional business undertaking carried on by that individual. The tribunal went through the contract in detail, comparing the way things worked in practice and some of the ancillary documentation. The tribunal, for example, found that it was incorrect to state that individuals had a discretion as to how the services were performed. There was a briefing document, for example, given to individuals, which included things like how to properly greet a customer — smiling is important apparently — and what to do if no one is at home to receive the package. Invoices were handled, it seems, entirely by City Sprint, and payable every Friday in arrears, did not require individuals to invoice City Sprint for the work they had done. They also found the right of substitution was in practice very limited. As such, the tribunal at the end of it all, and I think pretty readily, found that the contract did not reflect the reality, and that the clauses that had been put into the contract, and which would be counter to finding that the individual was a worker, were in fact not applicable because they were not applied in practice. The claimant was economically and organisationally dependent upon City Sprint and was working personally for them. On that basis, the tribunal did consider the AutoCleanse case, and the judge commented that whilst the express terms of the contract are key pieces of the jigsaw in deciding whether someone is a worker, she went on to say, quote, the bar is low before the true situation can be explored, unquote. This was in effect, in this case, based on the perceived inequality of bargaining power between City Sprint and the couriers. An attempt by City Sprint to point out that if there was found to be a contract on different terms from the terms put in writing and signed up to by the claimant and City Sprint before she joined, there had to be a point when this other contract came into existence, and when was that? However, the tribunal rather brushed this aside, saying they were simply able to look at all the circumstances across the entire period of time. So, having gone through all that, the tribunal found that there was personal service and that she was working on the respondent's behalf with very little autonomy to determine the way services were performed and no chance at all to dictate its terms. The tribunal decided that the individual therefore was a worker when she was on the courier circuit until she signed off in the evening. So, this is another case where an employer's apparently carefully crafted documentation was found not to reflect the reality of the situation. These cases are of course fact specific, and I have absolutely no doubt, but I should emphasise with no inside knowledge whatsoever, that City Sprint, Uber and others are looking at what changes they need to make to their systems so that, consistent with providing a quality service, they no longer seem to be directing matters so closely that individuals are denied autonomy. I think the main lesson here, and indeed the main lesson for all employers, is the need to ensure that contracts reflect the job which is actually being done, and that boilerplate clauses are not allowed to assume undue significance. Equally, if an employer wants to have a relocation clause, for example, or the flexibility to change job titles, to give just two random examples, it's important that these are clearly drafted, clear and reasonable too. Similarly, if a company is intending to give an individual autonomy in name, but not in practice, attempts to uphold the employee's autonomy will probably fall on deaf ears. So, that's the case of Dewhurst and City Sprint UK Limited. So, that brings us to the end of another podcast. Thank you very much for listening. I hope you enjoyed it. Please do let me know if you have any questions or comments coming out of that. It's always a pleasure to receive any feedback. I'm off to celebrate my 53rd birthday, and my mother is coming down from Edinburgh tomorrow, and we're off to the Victoria and Albert Museum, and apparently I'm being taken to see an exhibition of medieval embroidery, because that's how rock and roll you get when you get to 53. Anyway, thanks very much for listening, and until next time. Bye.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments or want to know how to claim CPD points, please email nick at nrobertson@mayorbrown.com. Our podcasts are an overview of the cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thanks for listening.